And then we'll move on to the next item on the agenda, which is pre-hearing consideration of indication of right against self-incrimination. As commission members can recall, and we'll talk to Phil in a minute here, but this is something that we asked the parties to brief. We had some discussion among ourselves about when somebody can invoke a Fifth Amendment right against self-incrimination, whether they have to testify or not. There was some discussion because it was invoked during the discovery process of whether that could continue and how to get a case ready for hearing. So because of that, the commission asked the parties to brief it and asked direction from the executive director on that. We have the parties here today. We have an active commission. I know everybody reads all the materials and have read the briefs. We can allow oral argument. We're not required to do so. And we can time limit if we want. Happy to take the commission members' perspective on how to proceed with oral argument and any time limitations you may have. So is there any discussion among commission members of how you would like to proceed on that? Yes, no, do you want to hear oral argument?
I think we've got counsel here, we've got the complainant here. I think in fairness we give them some time, but I think we should time limit maybe 10 minutes each or 5 minutes each. We read all the materials, but they're here. I think they should have the opportunity to be heard.
Mr. Bromer, that's a...
Well, I don't know. They sent us a pretty extensive briefing on this, but I don't have any problem with a time-limited discussion.
Ms. Coughlin? Okay. All right, so but given the comments of the commission, we'll hear oral arguments of the parties and limit each side to 10 minutes. If the, let's see, we have I guess we don't really have a rebuttal process because we asked for the submission. So we'll give 10 minutes for each side. There's not going to be a rebuttal. You say, each side say what they think about it, and then we'll hear from the executive director, and then the commission can debate among themselves and make a determination. So we'll start with the complainant because that's normally how we'd start. And then we'll go with the respondents. So the complainant, if you would like 10 minutes to argue your motion and address the commission, we will do so. We have read the materials. You don't need to repeat what you've already said, but you're certainly welcome to summarize it for the commission. So I feel like parties feel like they have to educate us from the beginning, but we've read everything. We've read the cases that you submitted to us, so you don't have to repeat everything. Just repeat what you tell us, whatever it is you think in addition to the briefs should be considered.
Okay, so I'm glad to be brief. However, I don't know what he's going to say, so there might be things he says that I would like to reserve time to rebut or to question. I know you may or may not let me do that, but I'm glad to be brief as a trade-off as to that, at least consideration of that when we get there.
Why don't you speak from the lectern? Just
Typically what we do in the legal proceedings, if you want to have rebuttal, you reserve time.
I'll reserve time.
How much would you like to reserve?
Half of my time.
Okay.
Okay.
5 minutes.
So, and I will, so if somebody can, it's 10:13 right now, so I'm going to begin. So.
My chrono's going.
Yeah, I think I'm learning a lot, and I think hopefully you guys are also learning a lot. I'm not a lawyer, but there's a lot of these things that I think are very important topics, not just for this case, but for cases into the future. You know, and I think there's actually two major things that came up is whether a person, I don't think there's any dispute about whether you need to, somebody can take the fifth. Okay, that's not the dispute. The question is it a civil process for taking the fifth? Can you take the fifth to every question, like where do you live? You know, things like that. What's the name of your treasurer? Questions that have nothing to do with criminal implication. Or can you be like a criminal process and totally not say anything? I think that's one thing. The other thing that came up in this is obviously the point of already having submitted an affidavit. And to me, the implication of what if people start coming before this commission and saying the affidavits they submit in the preliminary phase, they lied because it was beat out of them. Because that's the real issue with the affidavit. It's not that it was compelled, is that it's been caught that it wasn't the truth. And so Mr. Freeman doesn't want to have to address the material within his own sworn statements that he already submitted to this commission. I put a lot of stuff on my brief just to think real quick about a couple of those issues. I think you follow the civil rules. It should be a civil process. It's not a question of, I put some example cases that I could find. I'm not a lawyer. Maybe there's better ones. There are cases that involve the civil process of somebody trying to invoke their fifth. All I've ever asked is that Allen Freeman invoke his fifth under oath. Invoke his Fifth Amendment right against self-incrimination under oath, which is normal in a civil process. I believe he should absolutely be subject to cross-examination on his own sworn statements. On this argument that it's like, the police beat the confession out of the victim and it's not admissible type argument, I think it's nonsense. Your rules state, it was brought up before, your rules state that a person should file an affidavit and reply to a complaint. It doesn't say what they have to have in that affidavit. It says that they could be found guilty or they could be found accountable if they don't file any reply at all. That's what your rules say. Not that they will automatically be found responsible. In the other case we're going to talk about today, 2021-D005, Jean Schmidt, she never filed an affidavit. You didn't find her guilty, nor did I put forward that she should be found guilty. So the notion that also a witness cannot be cross-examined on their own sworn statements, when Allen Freeman could have had a sworn statement say, I'm going to assert the fifth in those sworn statements, and that would have covered the obligation. I put in my brief, I think it's essentially would be somebody saying, I'm not going to help you, prove it on your own that I did something wrong. And that would have fulfilled the obligation of your rules. But I think just, to me, the implications beyond this case, if I were sitting in your seats, the implications beyond this case of the mockery of the process that can result. If people come in and say they can assert the fifth like a criminal, purely like a criminal thing, not like a civil thing. They won't even address questions that have no criminal culpability. And that they can't be cross-examined on their own affidavits. And that they can assert later that an affidavit they filed in the preliminary process by which you would make a decision whether to have a full hearing or not, they can then later say, well, it doesn't matter because it was compelled. These are extremely dangerous things. I think I quoted, I can't remember from memory, I think I quoted some of your mission about this being, I'll probably use the wrong words, an expeditious process. This should be a process where we all, no matter what side of issues we're on, respect the idea that campaign finance should be transparent and follow the law. Not all these games. I think about this, I was thinking when I was writing this stuff, I can't tell you how many late hours I spent writing stuff and researching stuff as a non-lawyer, is how much time we spend on this stuff, how much time you spend on this stuff, versus the actual merits and facts of a particular case. It's ridiculous. It's ridiculous, and I don't think I'm the one disrespecting the process. I do think I am the one forcing the issue. And I think, I want to thank you guys for your patience and tolerance, even though I'm pretty good at bitching and moaning all the time. But I think these are important issues for the future of our state in campaign finance in terms of your role.
If you want to reserve 30 seconds.
No, I'm done. Thank you very much.
Do any members of the commission have questions for Mr. Hicks at this time? And for the record, I'm sorry, I should have asked him to identify himself. That was the complainant, Mr. Hicks. Mr. Bryan?
May it please the commission, as you know, I'm Don Bryan. I represent respondents as well as respondents' wife, Allen Freeman, in this case. I agree with complainant that this is an important issue as to whether or not filing an affidavit of response in the preliminary review will waive the rights against self-incrimination of a respondent. In fact, I had other cases, not this one, where we had not yet filed affidavits of response because my clients probably want to know what their rights are or aren't going to be if they do that. As a matter of clarification, we're talking about self-incrimination, and we, respondent, are talking about the self-incrimination rights we have under Article 1, Section 10 of Ohio's Constitution. We have never assertively pleaded the Fifth. And I understand the same self-incrimination rights that you have under the Fifth Amendment you would have under Article 1, Section 10, plus I believe some others. But we have never said we're going to plead the Fifth. You know, that is a semantic argument that the complainant wants to have people under oath saying, I take the Fifth. And I won't speculate about his reasons for doing this, but this is a political process. And I also don't want to mislead anybody. I mean, there are a couple of motions that are still pending. The motion about Susan Jones is no longer pending because she can be here on the 7th, assuming we all agree she's not a party. You know, if she's a party, she'd do the same. You know, I think the complaint's pretty clear she's not a party to any of this. But so she can be here on the 7th of October. And like any witness, you know, who is not a respondent, she can claim the rights against self-incrimination as to specific questions, but she doesn't have a right not to appear or answer questions at all. Because under Article 1, Section 10, in this Commission's rules, 3517-111B3A, a respondent in an Ohio Elections Commission procedure is in the same position as a defendant in a criminal procedure. As your staff counsel noted in discussing the subpoena power, this is an odd birth. It's a petition put a third something in terms of the procedures of the commission. We're partially civil, we do fines. We're partially administrative, we create rules and we do have advisory opinions and so forth. And we're partially part of the criminal process because you can refer respondents for criminal prosecution. And that is why, for over 3 decades, respondents have been treated in the Ohio Elections Commission in the same way as criminal defendants are treated in a criminal trial. Now, what does that mean when you file an affidavit of response? You know, because after all, if you waive your rights to testify by testifying in a proceeding, you can be cross-examined about what you have said that you have waived in that proceeding. And the question then becomes, what is proceeding? Is proceeding the entire case? Or is a pretrial proceeding, in our case, the preliminary review, a different proceeding from the trial of the case, which in our case is after the preliminary review if it's ordered for an evidentiary hearing. And the Ohio Supreme Court has answered that question. And they have stated, you've read it, that the pretrial proceeding is not the same proceeding. And if you waive rights to testify in a pretrial proceeding, that does not mean you waive rights in proceedings subsequent to the pretrial proceeding. That's the Ohio Supreme Court. And they're interpreting, once again, Article 10, Section 1. Maybe there are other Fifth Amendment cases out there that go differently, but we are bound by how the Ohio Supreme Court looks at it. And that's even if it were voluntary. Secondly, it has to be a voluntary waiver. And by voluntary does not mean it, as the complainant has suggested, that somebody's holding a gun to your head. It works with that phrase. It means that is it essentially a free and unconstrained choice to testify. And it's not a free and unconstrained choice to testify if your rules state that your failure to file a proper affidavit of response may mean that all the allegations will be treated as true. That doesn't mean, of course, that a lawyer can't argue that without looking at the facts, there's something procedurally wrong with the complaint and dismiss it on that basis. But it does mean you cannot contest the facts unless you have an affidavit of response. And that would place a respondent in a position where either you file an affidavit of response, which I had usually filed or asked clients to do, or you don't, and you waive your right to contest the factual allegations of the complaint. Yeah, a lawyer may be able to throw it out because it wasn't notarized or some other thing, but that's a different issue in terms of whether or not there's a legal argument as opposed to whether or not there's a factual argument. And secondly, there's also a right to contest those, even if it weren't coerced, even if it were a matter of trying to raise an issue that you can only raise by filing at the preliminary review an affidavit of complaint. And we cited those cases, as the Ohio Supreme Court once again stated, when a person's assertion of the privilege is penalized in a way that precludes that person to choose to remain silent, you can't use that against them. And it's not a waiver of the rights not to testify. We laid all this out in our briefs, and you've read it, and I don't want to tell you things you already know, but I did want to also state that we're focused on that issue today. And I don't want to mislead anybody. I'm probably going to file a motion to dismiss it to in a couple of days or whatever. But this is still an issue that's important to decide, not just for this case, but for, other cases that are coming up, so that we understand, and everybody understands going forward. Do you have to waive your right to file an affidavit of response to preliminary review to prevent yourself from having to respond to interrogatories and be deposed and testify at trial involuntarily, or not? It's an important issue. I think the answer is clear, but the commission needs to decide one way or the other.
Thank you. Any questions for Mr. Bryan? Thank you, Mr. Bryan. Mr. Hicks?
Wrote down 6 things as Mr. Bray was talking, and I break it in the rebuttal time. The first thing he mentioned was he has clients who are not filing responses because they don't know their rights. And I'm wondering, what rights are those? The rights to lie in affidavits? So the absurdity of, I think, as I said, it's not about being compelled, it's about being caught. The second thing is, he repeatedly says that he did not assert the fifth, but I'll read out of this is the filing for this. In fact, filing is that the respondent did not waive his rights under Ohio Admin Code 35171-11B3A. He keeps referring to this code, okay? And it keeps referring to the code, and the code is what says, B4, B says a respondent or witness may refuse to answer questions based on the right of self-incrimination guaranteed by the Fifth Amendment of the Constitution and Article 1, Section 10 of the Ohio Constitution. We continue to see Mr. Bray playing these semantic games with what's actually being asserted when the rule that he keeps asserting is very clear. The next thing that he brought up is this idea of compelled. His affidavit was compelled. Let me remind everybody here, what happens to this commission if people are allowed to lie in their affidavits they file in response to complaints and then later claim it was compelled, so that it doesn't matter? They have a right to respond in their affidavits saying they're taking the fifth, if they respond in an affidavit. I would assert that he is voluntarily waiving his right to be cross-examined on the things in his own affidavit when filing that affidavit. And let's remember, when he filed that affidavit, Mr. Freeman was represented by counsel. He was not a babe-in-the-woods pro se person coming in and representing himself. So I think that I wrote down 2 other things. I'm going to jump around here because I'm reacting to his points. But I like that you guys say that you give pro se clients some discretion. And I'm a pro se client. And people can make claims about me, but I have a very good reputation as a watchdog that's willing to put incredible amounts of time and effort into things like this because it's about right and wrong. It's what's right and wrong. It's about millions of dollars of corruption in Ohio politics, of which this is one of the cases. And I appreciate to give pro se clients the benefit of the doubt, but what message does it send when you look at how much effort, how many times I've had to drive here? I don't have an option to request mileage reimbursement to just try to get a case heard. I think, borders on the absurd and says that this commission cannot be functional for the citizens of Ohio if it doesn't, at some point, get clarity as that this is going to be an efficient process. What I think you guys should do is make Mr. Freeman take the fifth under oath. Say that he has to be cross-examined on his own sworn affidavit. If Mr. Bray and Mr. Freeman don't like that, they can take it to court. They can take it to court and let a court resolve how this commission is going to be able to have people testify or not, how they take the fifth, and whether they have to stand behind their own affidavits. To do otherwise is just going to make a mockery of the Ohio Election Commission going forward on any serious matter like this. We're talking about a case that involves $290,000 of money that was clearly spent on a campaign, for which the campaign at one point received an invoice by their own admission. This shouldn't be that hard. This shouldn't be that hard. These tactics throughout have been dilatory. You guys all experienced the negotiation about the interrogatories in complete bad faith, where then he refused to even sign off on his own interrogatories after all that time. And I just think there's obviously legal issues, there's legal things you need to consider, but I think there's a bigger picture issue also of the ability of this commission to serve the people of Ohio on any matters of consequence involving election finances. So thank you for the additional time.
Any questions, members of the commission? Mr. Richter?
Based on their The submissions that they provided, I provided you a memorandum outlining my particular position on this. With all due respect to the statements that the commission's process is civil, to me it is not civil, it is administrative. To me, there is a difference between an administrative process and the civil process, and, going to court in the civil proceeding, mainly because we do have the ability to refer matters for further criminal prosecution. And anyone before this commission is facing that possibility. Looking at the breadth of cases the commission decides and determines, is it likely? Not necessarily, because we look at today, we have about 110 cases on the agenda, and of those, the majority of those are whether someone did or did not timely file their campaign finance report, and the likelihood of one of those types of matters going for prosecution is incredibly rare. Alternatively, a case like this, a case like the Trevor Elkins matter, other cases that the commission has before it, where it is possible that criminal prosecution could take place, is a real thing. I think it is important for us to respect all respondents who come before us, give them the leeway that comes with this possibly being at the beginning of a criminal proceeding, and that, as I outlined in my memo to you, I believe that the commission's obligation to file an affidavit at the beginning of the proceeding is potentially persuasive, and could allow someone to feel an obligation to do so. With all the cases that we'll deal with after we get done with this case, many affidavits have been submitted. We deal with those, we act administratively, the case is over, it moves on. I would hate to see the commission's ability to get those kinds of responses potentially limited. If we were to make a blanket statement that we would not subsequently respect any invocation of self-incrimination rights by a respondent before us, I think it's critical. And so my belief is that the commission should allow Mr. Freeman to invoke his rights against self-incrimination in the future, based on the manner in which the subpoenas are submitted, affidavits are submitted to the commission. And so that's my primary position. I also thought it was Mr. Bry's arguments about the two-step process were interesting and somewhat persuasive. But my belief is it's critical to respect a respondent's rights and not put them in jeopardy, as it were, as a part of this process that could lead to criminal prosecution down the line. I will, one last general comment. I was impressed with, to me at least, I was impressed with both briefs submitted to the commission by the parties. I hope the commission was as well. I thought they were very incisive. But that's my position. I'll be glad to answer any other questions the commission may have.
Discussion among commission members?
I will say I was the one who was, I guess, putting forth the potential issue of self-incrimination by submitting the affidavit. But a further reflection, as I think about the chilling effect, if we don't have the ability to respond with affidavit to the preliminary review and have that held against you when you get to hearing, I think it would handcuff this commission. So I've kind of reversed my thought process based upon a review of all the information provided.
Any other discussion?
I mean, I agree with what Scott primarily says and what the executive director said. I think looking at the requirement that we impose upon a respondent that, or anyone that, or complaining that they have to file a affidavit, that language is clear in its face. It doesn't say anything in that language that by doing so, you are waiving your rights to any further proceedings where you might invoke the Fifth Amendment. So I just don't, And I also agree with Phil, I think both briefings were excellent, but I think the language is clear and unambiguous, and I don't think that we should go down the path of saying that if somebody fills out an affidavit that helps us deliberate whether or not we go forward, that that person then waives their Fifth Amendment rights. I think that would be disastrous for this commission.
Other commission members? So I would say, from my perspective, whether or not you have a constitutional right against self-incrimination doesn't make any difference whether you're in an administrative, a civil, or a criminal proceeding, in my view. If you are under oath, subject to testimony, you have the right to claim a right against self-incrimination if it could lead to criminal prosecution. That's sort of that's the corollary. There has to be the possibility. It's not, because I'm uncomfortable answering questions or I don't want to be before this commission. You have to have a real true belief that it could lead to criminal prosecution. You don't have to identify what that prosecution is, but on the other hand, I also think that it is a personal right of a party and that they have to appear and assert it. You don't get to have your lawyer waive it for you. You don't get to not show up to a deposition and just say, well, it's the 5th, so I'm not coming, because I think that right is restricted to questions that will incriminate you. So I would say that I agree that the briefings in this were good from both sides. I am less persuaded by whether you characterize your proceeding as civil or criminal or administrative. I think that the constitutional right relates to either actual criminal prosecution that is happening or the potential for criminal prosecution based on testimony under oath that can be used against you in another proceeding. So from my perspective, I wasn't as concerned about those issues, but the idea that somebody can just not respond to a subpoena, not appear, not have to be subject to questioning, and then assert their right personally as part of that questioning, I think that is part of the right under the Constitution and the process as well. So I don't think that people just get a pass because they file an affidavit or have an attorney show up. I think they have to appear and claim the right before the commission as part of, if they're subject to subpoena, or have an obligation to come before the commission. I don't think just having a lawyer claim before you is enough. So that's my own view. Happy for other discussion?
Well, I guess I'm not sure I take the exact same posture, only in that in civil proceedings, if I find questions being directed to my clients that I find to be objectionable or that could potentially put my clients in jeopardy, I'll object and instruct them not to answer. And so if we're trying to go through the process of saying he's not going to answer any questions, then to me it's why waste the time, effort, and money to go through the process if you're advising saying my client is not going to answer any questions. That's just how I feel about it.
Understood. Any other discussion from commission members? Do I have, well, I guess what is before us
It's
is
a single issue, isn't it?
a single issue of whether or not someone can vote, whether the filing of an affidavit waives the right of self-incrimination. That's the issue before the commission in this case. So the chair will entertain a motion.
I move that we follow the executive director's recommendation and find that if you file an affidavit before this commission in a preliminary hearing setting, it does not preclude you from invoking your right against self-incrimination as it relates to later hearings before this commission.
I second it.
Motion by Commissioner Norman, second by Commissioner Bromer. Any further discussion of commission members? Roll call vote, Mr. Richter?
Just give me 1 second. Mr. Norman?
Yes.
Ms. Kaufman?
Yes.
Ms. Tavares?
Yes.
Mr. Bromer?
Yes.
Ms. Cunningham?
Yes.
That motion passes 5-0.